Derek serves his clients by either leading or providing secondary counsel in civil litigation cases involving oil, gas, commercial disputes, real estate, personal injury, and collection matters. So I appreciate you joining us, and I'll turn it over.
Thanks, Austin. Thank you for inviting me to be here today. I'm glad to be here. I'm glad to see so many people here. I was telling Austin beforehand, I was the president of the Midland County Bar Association for 1 year, but I served on the board for several years, and it was hard for us to get this many people, and I understand y'all are kind of low on your normal turnout, so it's great to see everybody here, and I'm grateful to be here. Whenever Austin invited me to speak, I saw on y'all's website that y'all had posted, my profile. I believe you got it from my firm's website. And I think we updated that in like 2016, 2017. And so I was reading it. And since it was posted, I've had 2 kids. I haven't bothered to put the kids on the profile since then, so I need to do that. And then I noticed that it says we have 3 dogs. We do have 3 dogs. The problem is that one of the dogs on the website is no longer with us. We just have a different dog. So I've got some work to do on that, but glad to be here today. The topic that I'm here to speak on is something that I think everyone in here can get something out of, whether you're a landman or an attorney. It's a topic based on a paper that I wrote with my partner Harper Estes in 2018. Primarily based on a case that he and I had tried in Ward County and then appealed to the El Paso Court of Appeals and ended up going all the way to the Texas Supreme Court. And the evolution of that case kind of illustrates the importance of reading a lease or reading a deed or reading an assignment. The topic or the paper that I wrote was called Persuasion Inside Four Corners: How Principles of Oil and Gas Instrument Construction Drive Oil and Gas Litigation. It's a really maybe eloquent or boring way of saying just read the damn lease, I guess if you take anything out of this today, that's kind of the main point we're trying to get at. And why that's important to, just a concept that we kind of lose sight of is, in every oil and gas lease, you've got a lot of different terms. And a lot of the oil and gas leases we look at every day look the same, but when we really dive into the details of the specific lease that we're looking at on any given day, there's going to be some variances between maybe what we expect there to be in that document and what's actually in the document. So it's really easy sometimes to lose the forest for the trees. I'll use the example of, if you're looking at a dispute over whether there's been compliance with a continuous drilling provision. Obviously, you've got the lease and you've got the provision that you're seeing whether the operator or lessee complied with. But then you get into issues of, you got to look at the well file, you've got to look at drilling reports. Maybe there's an issue of whether they made a good faith effort to get out and repair a well within a certain time period to save the lease. And I had a case like that we tried one time, and we had weather reports that were introduced into evidence. Was it raining on this day? We had the landowner telling us, testifying about how he drove our contractors out to the well site on a tractor, and that to me was just a weird thing. We're talking about an oil and gas lease, and this guy's telling us how he's driving people out there on a tractor, which is relevant to the dispute, but it's easy sometimes to get lost in the details of what the dispute's about, and then we lose sight of, what are we actually looking at in the lease itself as to whether there was compliance with the lease or not. What does the specific provision we're looking at say? And that's easy to do when every day we're looking at the same types of documents. We might be looking at leases or assignments or production sharing agreements or whatever the document is, but when you see the same things over and over, it's sometimes easy to gloss over terms and variances in terms from document to document. An example recently from my practice was one of our oil and gas lawyers brought me a lease, and he said, there's a case, here's the issue, we're not being paid this royalty properly. There's a case out of El Paso that's right on point, it's right with us. You need to, because you're in litigation and you're a mean guy, you need to write this demand letter to the operator and you need to make sure we get us paid. When I actually looked at the lease was dated after this opinion that he told me about had come out. And the lease was written as if in a specific way to kind of get around that case. There was language in that lease that maybe wasn't typical, but it was obviously thrown in there to address this problem that was discussed in this case. And so I went back to him and I was like, well, did you read this? You know, there's 2 words in here that, you know, really changed the meaning of this. And he's like, no, I didn't read that. I guess I've got to look for that. And I was like, yeah, I mean, I guess that's a big deal. If you want to send somebody a letter threatening to sue them, you might want to look at that. But it's easy to get lost in that because we look at the same types of things every day. For litigators specifically, we kind of get wrapped up in, you know, we see it on TV, Law and Order. I was going to play, I couldn't get the internet to come up, but I was going to play the the direct examination in My Cousin Vinny of Marissa Tomei, you know, coming to the conclusion that the 2 cars, that they were wrong about the cars and that it couldn't have been the car that was driven by Vinny's nephew. We want that moment. We so badly want to just own somebody on the stand. We want to stick an email in front of their face and say, you said this, and why did you say that? And it's the type of emails that, you know, your HR lady gets onto you about for sending, and then when we produce in litigation, we kind of grit our teeth and be like, why did they say that? Why did they say that in an email? Can you not pick up the phone and just make the phone call? But we get focused on putting something in front of the jury that's going to give this big wow moment that we all want, you know, in law school. We all want to experience that. But as the case I'm about to walk through you with kind of explains, in the oil and gas context, it's largely irrelevant. The emails, extraneous documents, what parties intended, outside of what's stated in the agreement that's at issue, all that stuff is largely irrelevant. And that's because the courts are going to be the ultimate arbiter of any dispute that comes up in the oil and gas context. And in Texas, we abide by the 4 corners rule, which is essentially that any unambiguous instrument is only going to be construed based on the words that are actually in that document. Now, you can incorporate other documents into the document you're looking at, and some of the cases we'll talk about later will do that. But if there's no incorporation by reference into the document you're looking at, you just look at the document itself. And as the Supreme Court has explained to us, a document is unambiguous when it's so worded that it can be given a certain or definite legal meaning or interpretation. And so the 4 corners rule, the rule about unambiguous instruments, I think the best illustration of that I've seen in recent years was this case that I tried. So when my partner Harper Estes, we represented Anadarko against RIP Anadarko against Troex. I believe it was filed in 2014 or 2015. But the case essentially evolved, and these facts on this slide are what, if you were to pull the opinions from the El Paso Court of Appeal and ultimately the Supreme Court, these are the facts that you're going to see discussed in the case. And then on the next slide, I'll kind of walk through you with what was really going on the ground and just some of the weird facts about this case that is still, this case isn't pending, but there's still litigation pending related to this case. And like I said, that lawsuit was filed about 9 years ago. But essentially what the case evolved around was Anadarko had acquired some leases from not Troex, but another party. Troex took these leases from some lessors with the last name of Cooper, and then they flipped them to another party who then flipped the leases to Anadarko. And Troex, when they took the leases, they had a participation agreement with the party they flipped them to originally that said if, I believe Troex got some kind of override when they flipped the leases. And so to prevent that from being washed out, there was a provision that if there was any renewals, extensions, or top leases of those leases that were taken in 2007, if there were any renewals, extensions, or top leases taken within 1 year of the original 2007 leases terminating, then Troex would get a 5% back in. In 2011, after Anadarko had taken the leases, the lessors notified them that, hey, there's an offset well provision in this lease. There was a well drilled just on the other side of our property line. It triggered the offset well provision. You owe us a release. And Anadarko was like, yeah, our bad. But rather than give you a release or renew this lease or extend this lease, we just want to work out new leases with you guys. And so there's a whole series of emails back and forth with Anadarko and these Cooper lessors where they're discussing what are we going to do about the new lease, bonus terms, new royalty. The lessors wanted more onerous drilling commitments. And so ultimately the parties agreed to new lease terms. The lessors got a really good deal on the face of the leases compared to what the old leases said. So the parties in mid-June of 2011 signed these new leases. And then somebody at Anadarko said, hey, wait, I think it would be better or maybe cleaner if we also got releases of the old leases and we recorded those. The problem was, I'm not putting any blame on any landmen, but somebody signed the releases and recorded them, but they recorded them about 2 weeks after they recorded the new 2011 leases. So there's about a 2-week period where you're looking at the run sheet and you see 2007 leases, 2011 leases, release of the 2007 leases. So there's about a 2-week gap. Troex argued that there was a top lease, that the 2011 leases were a top lease of the 2007 leases. And they argued that because there was a top lease taken, the washout provision, anti-washout provision was triggered and they were entitled to a back end. And really the only evidence they had, because they weren't involved in our negotiations with the lessors, all they had was the run sheet, the public records. And so all they were relying on was this 2-week period where seemingly on the face of the county records, there were 2 leases in effect as to the same property at the same time, between the same parties. A little bit of background. So the lawsuit was filed. It just kind of sat there. My firm talked to Anadarko about, what's going on here, what's happening with this property. And it turned out the whole time we were fighting over, all the way to the Texas Supreme Court ultimately, we were fighting over a 5% back-end interest that the wells hadn't paid out. So if Troex were to win this lawsuit, they were going to get a 5% back-end with no upside. They were going to potentially owe money on their interest if they were to win. There wasn't really any discovery conducted. We didn't even take any depositions. We basically just got the other side's emails and correspondence, and they got our emails and correspondence. There was no formal mediation taken. I guess the problem or the circumstance that kind of pushed the case was it was pending in Ward County, and the judge at that time was Bob Parks, who is no longer with us. But Judge Parks was infamous for, if cases came in, he was going to get them tried. It didn't matter what the parties wanted to do. I'll explain in a second, it didn't matter if the parties agreed to a continuance between themselves. He wanted his docket moving at all times. And so if you filed a case in his court, about 2 weeks after you filed it, you get a fax that says you're set for trial on such and such date, which is usually about 6 months out. And you're like, well, I just wanted to kind of let it sit there. It just kind of pushed the issue on you. And so we knew we had this trial date, and there just wasn't a whole lot of interest in this case from both sides, and it just kind of languished until we were right up on the trial date, and the parties got together and like, what if we just try to do some kind of trade? Let's just work this out. You give us this, you give us that. We'll dismiss the lawsuit, kind of thing. And so we, Anadarko, came back to Troex and said, here's some stuff that we own. If you're interested in it, let us know, and then maybe we can do something along those lines. And so they were interested in some of the stuff we said we had. We're right up on a trial date, a few days away, and Troex comes back and says, that stuff that you said you owned, and you said you owned this much of it, you didn't really own that, or you didn't really own as much as you said you owned, so we really can't do this deal. And the first time that happened, Judge Parks was nice enough. We explained the situation like it was a mistake. He was nice enough to continue the case. The second, and then he reset the trial immediately for about 6 months after that. The second time the trial came up, again, Troex was like, hey, are you guys interested in working out anything along the same lines we discussed before? We said, yes, here's some stuff we own, here's what we own, are you interested? Let us know. They said, yes, we're interested in this, and we agreed to a deal. They did their due diligence. We didn't own what we said we owned, or we didn't own as much as we said we owned. Not pointing fingers, but it happened. And so this time, though, we went to Judge Parks, and both parties were in agreement that, hey, we're really trying to work towards a settlement. We think we can work this out. We're just kind of missing each other like ships in the night. Can you just give us more time to work this out? And he was like, no, the trial's set for Monday. I'll see you on Monday. And so we ended up heading to Ward County that next Monday. The trial took about a half day. There were only 2 witnesses. The principal of Troex basically testified that, hey, we had this participation agreement. I went to the public records. There's this 2-week overlap. It looks like a top lease. We're entitled to our back end. Our landman for Anadarko testified. We admitted several emails where he was trying to explain that, hey, we were just trying to negotiate new leases with these people. We always intended these to be new leases. We did not intend for these to be top leases. If they were top leases, we would have included, there was a specific provision that Anadarko used to indicate that it was a top lease. And it had all the provisions about what happens when the base lease terminates and went into detail. And that wasn't included in the 2011 leases. So 2 witnesses testified. It took about a half day. I did the direct examination of our landman. My partner Harper Estes did the cross-examination of Troex's representative. That was on a Monday. And then around Friday, another attorney in Midland who also represented Anadarko called our in-house lawyer, the in-house lawyer we were working with in Anadarko, and said, hey, I had a hearing in front of Judge Parks today on Friday, and he told me all about this trial y'all had over this back end, these leases and top leases, and he said he's going to rule for Anadarko. And we were like, well, great. It was like, you might not want to tell the, your in-house client about that. You might want to wait until he actually does the ruling. But we were going into that weekend thinking, great, we won. And then Monday or Tuesday, we got a fax from Judge Parks that said, no, Troex wins. So I don't know what happened. I don't know who said what or who said what when, but we were looking at a judgment that said we lost. And we didn't really understand why, because there was a Texas Supreme Court case that said when you execute new leases, a fairly new one, that said when you execute new leases with the intent to terminate the old leases terminate automatically or immediately upon execution. There's no need for a separate release. And so from our perspective, the release was totally irrelevant. And we had all these emails going back and forth with the lessors saying, Anadarko was the one offering a new lease to these people. And there was no mention of a top lease or a renewal. We specifically said we weren't going to renew the old leases. And so I wrote the brief to the El Paso Court of Appeals. My partner Harper Estes did the oral argument. And in the briefing, we talked about all these, we didn't really talk about the leases. We talked a lot about the releases of the leases and that 2-week gap and what happened, why was there this gap or this overlap. We talked a lot about the emails and the oral testimony from our landman about how he worked with the lessors to get these new leases, and Anadarko wanted to do new leases, and we gave them all these great drilling terms and this new primary term and a higher royalty. And that's a lot of what the briefing talked about. And the El Paso Court of Appeals looked at it, and they pretty much copied what we had said in our briefing. A lot, if you read the opinion from the El Paso Court of Appeals, they don't really talk about the lease. They don't really talk about the participation agreement. They talk a lot about these emails and all these extraneous documents and what did the parties intend and what was meant by this and that. And they were trying to really, it felt like they were trying to divine the parties' intent in the leases from all these other documents. But given what the parties had provided them in briefing, you can't really fault them for that. And the Court of Appeals looked at it and they said, really all Troex has is this 2-week overlap. And we don't think, based on the law, we don't see any evidence anywhere in the record that there was any intent for these 2011 leases to be top leases. And so we're going to find that that 2-week gap or 2-week overlap, it's just irrelevant. That's not any evidence that any party intended for any of these documents to be, or for the 2011 leases to be top leases. And therefore, there's no evidence to support the judgment, and we're going to reverse and we're going to render for Anadarko. That then triggers a whole series of deadlines with the Texas Supreme Court. And again, we're talking about a 5% back-end working interest that's underwater, that is basically worthless, and we're still fighting with it, still fighting over it to the Texas Supreme Court. And we all thought, because the Texas Supreme Court's jurisdiction is discretionary, surely they're not going to take this case. It was a half-day bench trial in Ward County on a Monday. There were 2 witnesses, there were maybe 5 exhibits. It's not the type of all-out $1 million litigation that the Texas Supreme Court is going to look at. But it only takes one justice of the 9 on the Texas Supreme Court to, once a party files a petition for review, to request the other party to file a response. And that happened. And we were like, sure, one justice may be interested in it. The Texas Supreme Court's really interested in oil and gas cases now. There's if you look at the statistics, the number of oil and gas cases taken has kind of risen pretty dramatically over the last 10 years or so, as the court tries to wrestle with various issues and give guidance to the industry. One maybe want to look at this issue, but it takes 3 to request full briefing from the parties. And then they did that. And then they requested oral argument. And so by this point, we had, Anadarko had also hired Deborah Hankinson, who was a former justice of the court, to prepare the brief to the Supreme Court and handle the oral argument. And Harper and I at my firm were still participating in the case, reviewing the briefing and everything. And it went to the Texas Supreme Court, and again, the parties in all the briefing were talking about emails, we're talking about the releases, we're talking about who intended what at what time based on all these other actions except for what's in the 2011 leases or even the 2007 leases themselves. And so the Texas Supreme Court said basically the issue is what we're looking at to determine is when these 2011 leases were executed, was there any evidence of any intent in the 2011 leases themselves, and not anywhere else, but just in those new leases themselves, was there any indication of any intent that those documents be top leases? And the opinion it's fairly short for a Texas Supreme Court opinion, but there is a good bit of discussion about some side issues that were raised by the various parties. But if you look at the opinion, there's really only one paragraph, about 4 sentences, that deals with this issue of was there any evidence in the 2011 leases themselves of any intent for those to be top leases. And the court says no. TROEX didn't even point us to any language that could indicate these are top leases, and we don't find any. And so just in this one paragraph, the rest of the opinion is pretty much irrelevant. This case had been going on for 4 years by this point, fighting over a 5% back-end working interest that is worth nothing. And it's just thrown out by the Texas Supreme Court in one paragraph. And it's odd for the Texas Supreme Court to write on an issue and affirm the lower court. Usually they're reversing the lower court and they're writing to clarify or correct something. And I think that's what they were doing here too. They believed that the El Paso court got to the right conclusion. They just didn't agree with the analysis of how they got there. The Supreme Court said we're not going to look at emails and correspondence and communications. We're not going to look at this release that's really not even necessary because the parties, as indicated in the 2011 leases, clearly intended for those old leases to terminate. So all this other stuff is just irrelevant. And so that point made by the Texas Supreme Court in that case is just a good reminder, and I think it's something, like I said before, that we lose sight of, that we cannot lose the forest for the trees. We have to remain focused on the specific documented issue, the specific verbiage in that documented issue, and we can't get held up by or distracted by what did somebody say in an email about what that means. It doesn't matter. It only matters what's in the document that we're looking at. In that case, that opinion from the Texas Supreme Court came out in 2018, and shortly thereafter in the same term, the Texas Supreme Court issued 2 other opinions that kind of reaffirmed this principle in Endeavor versus Discovery and XOG versus Chesapeake. And these are both very similar disputes over essentially the same issue, and the facts are almost the same. But, and you would think based on the similar fact patterns, the similar issues, the opinions being issued on the same day, that the Supreme Court would have came to the same conclusion in both cases. But the key difference between the two cases was the leases at issue and the specific language that the parties were fighting over. So in the Endeavor and Discovery case, Endeavor was the prior lessee on this property, and they drilled a well, and after they drilled the well, they assigned themselves an 81-acre proration unit. In the lease, however, it had provided that whenever you drill a well and you're handling the proration unit, you can assign yourself the maximum allowed by the Railroad Commission field rules applicable to wherever you're drilling. Those field rules had permitted Endeavor to assign itself up to a 160-acre proration unit. So there's about 80 acres that Endeavor could have assigned itself, but just didn't. I don't know if somebody didn't read the field rules or didn't know what they were, just assumed what they were, but whatever happened, and they lost out on 80 acres. Well, Discovery took a lease on the 80 acres that Endeavor could have assigned itself, but didn't, drilled a well, and Endeavor sued it for trespass, saying, hey, wait, this lease says that we're entitled to a proration unit up to 160 acres. You're in our 160 acres. And Discovery said, wait, you didn't assign yourself that other 80 acres. You're limited to what you assigned yourself under this lease. And so they fought up to the Supreme Court. In a parallel case with very similar facts, like I said before, there was a lease at issue in the XOG Chesapeake case that affirmatively set the proration unit. So there's no action required by any party. The lease prescribes what the lessee or operator is entitled to as a proration unit, just as a matter of course once the well is done. And that proration unit is the field is what is established by the field rules applicable to where the well is drilled. So Chesapeake was the initial lessee in this case, and it, like Endeavor, only assigned itself 820 acres on its proration unit, although the field rules had allowed it to assign itself up to 1,920 acres. So XOG came in and said, filed a declaratory judgment action saying, hey, there's about 1,100 acres here that we feel is like up for grabs. We have a lease on it. We want to drill a well here. We want a declaration from the court that we're entitled to do that. So both these cases go up to the Texas Supreme Court, and the winners on the same day that the two opinions came out were Discovery and Chesapeake, who, if you look at the facts, were in totally different positions, because it was Discovery who was coming in as a secondary lessee trying to drill where it contended the proration unit didn't exist, and Chesapeake was the initial lessee trying to say, hey, wait, we're entitled to this proration unit. As the initial lessee under this lease. And so the difference was, in the Endeavor Discovery lease, the operator had the discretion or option to assign itself up to the field rule maximum allowable proration unit, but they had to take that affirmative action of assigning themselves that proration unit for it to be effective. In Chesapeake's case, however, although it didn't assign itself the full maximum allowable, the lease just automatically conferred it that right or that acreage without the need for any affirmative assignment or action by Chesapeake. And so both of those parties won. And so if you look at the analysis in the Court of Appeals opinion in the Troex case, and you look at the ultimate conclusions the courts reached, or the Supreme Court reached in these in the Endeavor and XOG cases, the disputes probably turned out differently than one would expect if you just looked at the factual circumstances, the emails that were at issue, what parties said on the stand, and just maybe by logic, without looking at the documents that were the core documents at issue in those cases, you might expect different conclusions. But the Texas Supreme Court has been clear that when we have a lease in front of us that's unambiguous, or a deed, or an instrument, a contract, any type of instrument that we have to construe, we're going to look within the four corners of that instrument unless there's an ambiguity, and there's very rarely an ambiguity. And so for all the lawyer tools that we learn, for all the emails we can stick in front of a witness in a deposition and try to make them cry and go back to the office and joke about, what we did to this person or that person. It's largely irrelevant. It's really going to come down to what words the parties use in the agreements at issue and what the courts determine that those mean. And I've laid out here, there's, this issue of just reading the damn lease, like I said before, or reading the document that you're looking at. It's going to apply to a myriad of different issues that are applicable in the oil and gas context. And so on this last slide here, I've kind of laid out some cases that are working their way up, if you're a law nerd like me and you're interested, or some issues that are working their way up through the courts right now. There's a case, there was an opinion in June from the Eastland Court of Appeals in Apollo versus Apache. And it's a pretty complex case involving a lot of purchase and sale agreements. But if you read the opinion and you look at the parties' briefing, the case is now on its way to the Texas Supreme Court. If you read the parties' briefing before the Texas Supreme Court, the key case they're citing is the Troex-Anadarko case. They're totally on different ends of the spectrums in terms of complexity. I mean, the Troex case was essentially a one-issue case, and here you've got 4 different purchase and sale agreements. You've got economic issues. I believe the lawsuit, when it was filed, was initially for $1 billion, and it eventually got pleaded down. But these principles that I've been talking about are equally applicable in a massive, complex litigation situation like this Apollo Apache case as they are in a one-issue case like Troex and Anadarko. Fixed versus floating royalty conveyances, I've cited here. There's been a lot of activity in the Texas Supreme Court. I've cited the 2 fairly recent cases that have come out on that. And then there's a whole myriad of cases going through Eastland and San Antonio and El Paso. And the issue essentially is the double fraction conveyance of a royalty interest. So a lot of times in old deeds, you'll see conveyances of, let's say, 3/16 of 1/8 royalty. Well, the issue becomes, did they really mean, because back then, I guess a lot of people assumed that the royalties that were going to be in leases were going to be 1/8 for perpetuity. And so they just kind of use 1/8 in that context as kind of a placeholder, so that when you're doing the royalty conveyance, that's an indicator of 3/16 of the whole royalty interest. Well, it could also be read as 3/16 of 1/8, multiplying the fractions, which is a much lesser conveyance. And that's a fixed conveyance. A floating conveyance is 3/16 of the whole. And whatever the royalty rate is in a given lease, you multiply that by 3/16. And so there's a whole myriad of cases on this issue that are working their way up. And the Texas Supreme Court has been clear, like it was in Troex, that you have to read the specific instrument, deed, contract at issue. There is a kind of a sidestep or a fix, if you want to call it that some of the courts are applying. It's called the estate misconception theory. And essentially what they're saying is, we know that all these people, or a lot of the people that were drafting documents in this era, they just assumed that every lease from there to perpetuity was going to be 1/8 royalty. And so when it looks like that's what the assumption, when you read it as a whole, when it seems like that's what the understanding the parties were under when they drafted that, then we'll just kind of, even though that's in the document, even though it says what it says, we'll just kind of look past that. We'll kind of disregard it. And if the rest of the agreement looks like they intended to convey, 3/16 of the whole, then we'll enforce it that way. The last kind of issue that I've seen or am working on is allocation wells and production sharing agreements. There's not a whole lot of cases. It's been really slow going getting these cases up to various courts of appeals. But essentially the issue comes down to, if you have a horizontal lateral going over multiple properties and you don't have a production sharing agreement with enough lessors, all the lessors, and the Railroad Commission still issues you a permit, is the permit valid? Is the well a trespass if the lessor hasn't consented to pooling, because we don't have forced pooling in Texas? There's a case out of, right now, I believe is back at the Railroad Commission, but the Opiella opinion that I've cited here, or case that I've cited here, there's a landowner down in the Eagleford who sued their operator saying, hey, we didn't agree to pooling, we didn't agree to a production sharing agreement, you've drilled this horizontal lateral across our property and other properties, and we didn't consent to it. And the Railroad Commission issued a permit anyway, and they sued the landowner sued the Railroad Commission. There's a district court judge in Travis County who invalidated the permit, voided it, said that it didn't comply with certain legal standards, and then I believe it went back to the Railroad Commission at this point. And so there's some coupling litigation with that between the landowner and the operator that my firm is involved with. And so that's just another issue to watch. And so I'll just leave you with, like I said before, just read the damn lease. It says what it says, it means what it says, that's all you have to look at. Unless, like I said, there's some kind of incorporation by reference of other terms or agreements. But just don't lose sight of side documents, other correspondence, or something that just sounds good, or, but doesn't really mesh with what the parties said in the agreement themselves. And so I really appreciate y'all inviting me out today, and if anybody has any questions, I'd be happy to answer them. Okay. Well, thank you, Austin, again, and I appreciate it.
Thank you, Derek. Hopefully we all avoid any litigation situations, but please keep Derek in mind if you come across anything you need help with. We're pretty low on announcements to make. I do want to say thank you for all the participation at the clay shoot last week. We had a ton of volunteers, a lot of shooters. Big shout out to Gareth Brewer and Josh Anderson for directing it and making it go smoothly. So other than that, I appreciate it and have a good day.